My Lord, I'll draw your attention to paragraph 5, 6, and 7 of the said of supporting affidavit.
5, 6, 7.
My Lord, at paragraphs 5, the deponent, one Mr. Edwin Meto, indicates that on the 10th of June 2026 at 1:06 a.m., the user, who is now the subject, the applicant herein, made another publication indicating that the president was flying from Norway to Finland on board a private jet. My Lord, you realize that this is an averment of facts. And being an averment of facts, my Lord, a judicial officer cannot be in a position to test the veracity or the authenticity of that averment in the absence of evidence. That is to say, my Lord, none of us as Kenyans knows whether the president was on board that flight or not in the absence of a manifest. And a manifest, my Lord, you find it under the Civil Aviation Act. And my Lord, the reason why I'm pointing out paragraph 5 is because paragraph 7 would not stand in the absence of the averment under paragraph 5. Paragraph 7...
Sorry, Mr. Njiru, let me get you correctly. So you are saying the flight manifest would have been a necessary document?
Yes. So that, my Lord, paragraph 7 can have some legal footing and factual footing. And I'll submit on it, my Lord. They say, and equally paragraph 6, but paragraph 7 is what is of most importance because it's now the one that is now criticizing into the alleged offense. They say that the motive of the alleged tracking remains unknown and the information published by the said user has caused apprehension on the person of the head of state. The deponent is presupposing that the head of state was on board that aircraft. Yet none of us knows whether or not he was actually on board. So, my Lord, how can an offense crystallize? Because an offense must be based on facts.
But Mr. Njiru, don't you think that is then a matter for the court where they intend to charge? If they charge for publishing information that you say,
yes, my Lord,
the basis would be this kind of information.
Yes, my Lord.
Then what I hear you arguing now would be a matter in challenging the charge.
That would be correct, my Lord. But remember, the charge will be informed by the information extracted from this particular
devices
application.
Okay.
This is a device. Actually, this application is a device. Is a facilitator. So, in that sense, my Lord, this application itself amounts to an abuse of the court process. And judiciously, a JO would ordinarily not have the basis upon which an application such as this one would be admitted. Number 2, my Lord, and this is a constitutional aspect of it, that the person who is said to be apprehensive is the head of state. Article 143, my Lord, immunizes the head of state from criminal proceedings. That means the head of state cannot even record a complaint anywhere in the Republic of Kenya under any other OB because he is immunized. So, to the extent that, my Lord, the averment of the apprehension of the head of state cannot be ascertained due to the application of Article 143, then you realize that this application breaches and violates Article 50, a right to fair hearing. Because an applicant such as Halima or the defense would never have the opportunity of testing the veracity of this alleged apprehension. We will never have Mr. William Ruto appear before any judicial officer for ascertainment of these averments. So the premises on which this application itself is premised on, my Lord, it's itself unconstitutional. And we're asking this court, my Lord, pursuant to Article 165, to pronounce itself on the constitutionality of such an application, where application is premised on violation of a right to fair hearing. And my lord, you might even want to go further and deploy your tool of supervisory jurisdiction to supervise whether or not, my lord, such an application is tenable. It's legal propriety before a court of law.
Well done.
So that, my lord, we may avert future abuses, my lord. Because we are not sure where the president will go tomorrow, whether our personnel will be able to track or not. I'm also
Njiru,
my lord.
just to benefit from your,
Yes.
your reasoning on this, when you invoke Article 143,
Yes, my lord.
talk about the immunity,
Yes, my lord.
are you by any chance suggesting that because of that immunity, the head of state is not entitled to protection of the law?
He is entitled to the protection of the law, but he cannot invoke criminal jurisdiction in his own capacity. And an application such as this one cannot have the reference or cannot refer to him as a man complaining about the apprehension, because you'll never have him on the dock at any given time.
As the complainant.
Yes, as a complainant. Therefore, you'll never be able to test the veracity of the averments of apprehension. Because he's the only one who can say, when Halima tracked me, I felt I was apprehensive.
Okay.
Yes, my
Get
lord.
your point.
We are most obliged.
Thank you.